The next rule of interpretation that we're looking at is the rule of adjustum generis. Now, the adjustum generis rule can be understood along with the secondary rule of interpretation, that is the expressio unis est exclusio orderius principle. So, we'll be looking at both of them together. For the purpose of this, of both these rules of interpretation, I'd like you to look at the example that is there in both of the principles of interpretation. So let's read the example for the rule of adjustum generis. That is, a tax of 18% has been imposed on tomatoes, carrots, onions, etc. starting from 1st January 2022. So what can we understand over here? That the tax of 18% will be imposed on not only the tomatoes, carrots and onions, but rather it will apply to the entire class of vegetables for the purpose of this law. So just by mentioning only tomatoes, carrots and onions, does it mean that the cucumber does not attract an 18% tax, or that your say your capsicums or certain other vegetables do not attract the tax? No, because we can see the word etc. there. So what can we understand from the rule of adjustum generis? That the law, rather than having to specify each and every item in that species or in that class of objects, they are simply mentioning a few of them and then followed by a general word. Okay, so after keeping this in mind, we'll come down to the second principle, that is the expressio unis est exclusio orderius. Remember, for the purpose of easier studying, I call this as the exclusion principle. Now let's look at the example under this one. The same tax of 18% has been imposed on tomatoes, carrots and onions starting from 1st January 2022. So what is the difference between the previous sentence that we had read and the current sentence that we are reading? The use of the word etc. is missing. The word etc. is not there. So if the word etc. is not there, then that means a tax of 18% has been imposed only on tomatoes, carrots and onions. Cucumber will not get 18% tax. Your bitter gourd will not get 18% tax, simply because the law has mentioned only these three words, and that is why we call this as the rule of exclusion, or more specifically we say where there is an express mention of one thing, it excludes all others from its ambit. So therefore, the specific mention of a few things in a particular class can simply exclude everything else in that class, and that is what the exclusion principle says. Okay, so for the purpose of understanding exclusion principle, it has to be read against the adjustum generis principle, because please understand, in the rule of adjustum generis, they are saying they're using the word etc. and that by itself changes the whole matter of things, in the sense that if you have to apply the rule of adjustum generis, the tax would be applicable to all the vegetables simply because of that one word, that is the word etc. But then in the exclusion principle, the word etc. is not there, or the general word is not there. Hence we can say that it's applicable to only those mentioned within the law, because then the 18% tax will be applicable only to those three vegetables and nothing else. So let's break down the rule of adjustum generis here. The literal meaning of the word adjustum generis means of the same kind or species. So it applies in the case of the following four scenarios. That means the following conditions must be satisfied before we can apply the rule of adjustum generis. 1. There's an enumeration of specific words. That means onions, tomatoes, carrots. There are specific words being enumerated in the law. They belong to a certain class or category. In this case, which class or category do they fall under? They fall under the vegetable category. So onions, carrots and tomatoes. Correct? Now, the class or category is not exhausted by the enumeration. Are there only 3 vegetables in all the vegetables that we are aware of? Obviously not. So, these 3 do not represent the entire class, but rather they represent some elements or some items in the class of vegetables. And there is no indication of a different legislative intent. That means it is clear from the readings of the statute that the law wished to impose an 18% tax generally on all vegetables. And if these rules are satisfied, then we can apply the rule of adjustum generis, because the purpose of applying adjustum generis, one, is more to do with a logistical problem, because the law cannot keep enumerating each and every vegetable in that class. And right now the example that I'm giving you is only with vegetables. It could apply to it could apply to cars, it could apply to machinery parts, to hardware, to construction material, to chocolates, to the different types of milk products. So since it becomes a logistical nightmare, and therefore the use of the word etc. Okay. However, the courts are very clear on one thing. When you are applying the rule of adjustum generis, you apply it with great caution, because you are departing from the natural meaning of words in order to give them a meaning which is the intention of the legislature. That means you are presuming that the etc. was put there for a reason. In expressio unis exclusio alterius, or otherwise known as the exclusion principle, it says the express mention of one thing implies the exclusion of all others. So therefore, when the law specifies certain enumerations of a particular class, then the law will apply only to that class and shall not apply to any other members of that class, because the specific mention of those vegetables excludes all other vegetables, and that for you is your exclusion principle. We now come to the concept of the rule of contemporaneo exposito. The maxim is to be read in the following manner: contemporaneo exposito est optima et fortissima in lege. So, what does this say? The contemporaneous exposition is the best and strongest in law. What do you mean by contemporaneous exposition? They're saying that sometimes the meaning of certain words, especially in the English language, changes over time, or it attracts different meaning over a period of time, and the meaning of a word can be different at the time that the law was drafted, and it may have a different meaning today. Okay, so for this purpose, let's look at one example. Now, as we have known, the word damage means harm or loss or hurt being caused to people. The word damages means monetary compensation. The only difference is damage means harm, whereas damages could mean monetary compensation. Now, this is purely from a legal standpoint. That is, only in a court of law will they say, I will award you damages, or I will grant you monetary compensation, because the meaning of the word damages at the time the civil procedure was drafted meant monetary compensation, and hence that is the strongest position in law, or that is the best meaning in law that we are meant to take. So let's come back to the meaning. It says, if words have undergone a change in meaning over time, then the best meaning is the meaning which was given to it at the time that the law was drafted itself. Okay, so this clearly means that even if there is a natural or ordinary or popular meaning of a word today, if it had a different meaning at the time that the law was drafted, then it is that meaning that we'll go with, and not the ordinary or popular meaning as we know today. And that is only known as the rule of contemporaneo exposito. So, let's say a wrong meaning of a word has been attached to a word. can the court change the meaning of the word simply because the wrong meaning was attached to it? The answer is an absolute no. The court cannot change the meaning of the word and rather must use the exact same meaning because it is the contemporaneous exposition is the best and strongest position in law. There are only two exceptions to this principle, where they are saying that where title may be affected or where contracts have been entered into on the basis of such wrong interpretation. So only in these two situations the court will change the meaning of the word so as to take care of the facts and circumstances of the case. Lastly, we have the principle of nocitur a sources. Now, the word nocitur a sources is a very interesting concept because it says it is a word that is known by its associates. That means it is known by its prefix and suffix. Okay. So let me give you an example for this, the word nocitur a sources. The word that I am using over here is Arti expended her alt metroamin on hospital bills and other expenses. Now my question is, what do you mean by this word alt metroamin? Now just for a little bit of context, the word alt metroamin has been made up by me at the moment. But let's just say, for example, that this word is not exactly made up in the sense that I have made it up right now. We still need to understand the meaning of this word, because sometimes some laws will have certain words which exist in the following manner. So then what can we understand from this particular sentence? We can understand that a person has expended something. That means has given something all on hospital bills and other expenses. So to a large extent I can say that this is somewhat resembling a form of either currency. It sounds like a medicine, but from what we can understand, that because you give money in return for, you pay money for your hospital bills and certain other expenses. So hence, by reading the other prefixes and the suffixes, I arrive at this meaning, saying that alt metroamin could mean currency. Okay, and this is what nocitur a sources is saying. A word is to be judged by the company that it keeps. So when two or more words are having analogous meaning are coupled together, then one word shall be constructed in the manner deriving its meaning from the other. Now this can only be done when there is no grammatical meaning, there is no ordinary or popular meaning that is well known to the people. So in this case, it has to be presumed that this word means this, or this word could mean currency, which is what is meant in this particular line. Okay. However, they are saying that this rule shall not apply when the context excluded that principle, sufficient reason can be assigned. That is, it is proper to construe a word in one part of an act in a different sense from which it bears in another part of the act, where it would cause injustice or absurdity, where different circumstances are being dealt with and words are used in different context. So the word nocitur a sources, or this principle, is a sort of last resort principle in case we are unable to assign a meaning to that particular word. In that time, we will interpret the word along with its associates. Now, this principle of strict and liberal construction that we can see is a type of construction that is given to its own type of statutes. So to first understand the difference between strict and liberal interpretation, we first need to understand statutes which are known as penal statutes and remedial statutes. So quick recap on to the beginning of the chapter, where we saw remedial statutes are those statutes which help to uplift certain people in society, or to give certain benefits and to enable them and to uplift them. So remedial statutes are to provide a remedy to people, whereas penal statutes are meant to punish people. That means it's saying that if you do this activity, I will punish you. And punishment can refer to forfeiture of property, it can be a penalty, or it can even be imprisonment. So when we look at penal and remedial statutes, there is a certain way in which we interpret both of them. Now ideally you must be wondering, why is there even a difference in their interpretation? Shouldn't all laws be interpreted equally? Now while that is the general rule, there is a slight change in interpretation when it comes to remedial statutes and when it comes to penal statutes. So let's take for example the first one, the penal statutes. We can say that the Indian Penal Code, which has been substituted by the BNS, okay, or the Income Tax Act, these are all laws which are, like, say for example the BNS, the Bharatiya Nagarika Suraksha, provides for certain offences, and that if a person has committed this offence, then they will be punished under the law. So these punishments usually can vary between fines as well as imprisonment, or to the maximum of a death penalty. So is it possible for a judge to interpret the statute in such a way so as to say that, okay, while this offence gives a maximum punishment of only 2 years imprisonment, I believe that you have committed a crime which is way worse, and therefore I will grant you 7 years imprisonment. Okay, what I'm trying to explain to you all is that the law itself provides for a maximum punishment for this offence, and that is 2 years. But then can the judge be liberal in his interpretation and grant a 7-year imprisonment? The answer here clearly is no. If the maximum imprisonment is only 2 years, then the judge cannot exceed that limit. However, with remedial statutes, say for example your Domestic Violence Act or your Workmen's Compensation Act, these are all laws which help to uplift certain people. So say for Domestic Violence Act, let's assume that the victim is entitled to a maximum compensation of 40,000 rupees. However, in real life scenario, the victim might be a mother of 3 children, and the hospital bills itself may have come up to close to 80,000 to 90,000 rupees. So in this case, if the victim is entitled only to 40,000 rupees as a maximum compensation, it would kind of defeat the very purpose of the law, because the Domestic Violence Act comes out just to protect victims of domestic violence. So in this case, the judge may extend the compensation beyond 40,000 rupees to even maybe a 1 lakh rupees. So this is known as liberal construction. Even though the law says one number, you are still going beyond that number and granting that kind of protection. So now I hope the difference between remedial statutes and penal statutes are clarified, and that for penal statutes it follows a strict construction, whereas liberal construction is followed for remedial statutes. So let's just see what it has to say. Socially beneficial construction. The approach of the court in such cases must be to advance the beneficent purpose of the law, and it will normally favor the persons in whose favor the law has been passed. So the Maternity Benefit Act is a law that protects employment of women at the time of maternity. So therefore women will be granted fully paid wages during absence from work. The Employee State Insurance Act is also following the exact same thing. Our domestic violence provisions also the same thing. Our Workmen's Compensation Act is also a different example. Strict construction says the court must adhere to the strictest provisions of the law, and the court should not only apply the provisions of law strictly, they must also comply with the spirit of the law. They cannot add any additional burden than which is already provided in the Act. So an additional burden can even include imprisonment or fine, or even any form of penalty. Okay, so this is your difference between your strict interpretation and liberal interpretation, which is applicable to your penal statutes and your remedial statutes respectively. And so, my friends, these are your basic principles of interpretation under your Interpretation of Statutes Act. So we see 8 of them, we see 8 to 9 of them, 5 of them in your primary rules and 4 in your secondary rules of interpretation. Okay. The word presumption. What do you mean by presumption? It means to presume something. So, ma'am, presume means the same as presumption. Yes, you are right. What is presuming? I think a better word will be assuming something. You are assuming that something is correct, that you do not have the actual facts, you do not know whether it has actually taken place, but you're going to assume that if these events have taken place, then this is correct. So some examples of assuming I'll give you. It is presumed that a brand, a product which is of higher price is of a higher quality. Is there an actual correlation between the two? Sometimes we could have highly priced products which are of very low quality, not very low quality, of lower quality. And that sometimes even lower priced products can be of very, very good quality. But what was my assumption? My assumption was that if it costs more, then it means more money was put into its quality. Correct? So this could be an example of assumption. Now the same way, we make certain assumptions when it comes to law. Certain assumptions relating to whether it is the law itself or how a certain provision is to be interpreted, etc. So let's read some of these presumptions for better understanding. We won't go in exact order of that which is provided in the screen before you, but rather I will randomly choose a few points and read them. The first one: the law compels no man to do which is fruitless or futile. So in other words, the law will never compel a person to do something which is impossible in nature. What do I mean by impossible in nature? In the sense that if I ask a person to run 5 kilometers in 5 seconds, I will say that is an impossible activity. Second example: if a father puts a condition on the son saying that only if you marry this girl, I will grant you an estate. The said girl passes away. So at this point, the son will not be able to perform that activity because it is impossible to do so. He cannot marry a dead person. Correct? So the law will never compel a man to do something which is impossible. This is the first presumption. Then, the legislature knows the state of law. It is presumed that the legislature, whenever they pass the laws, they know exactly what they are doing, okay, and that they have every interest or every piece of knowledge relating to that law. So there's a general saying that goes this way: how is it possible for men sitting in parliament, men and women sitting in parliament, to know everything about the world? to know everything on every topic so as to make a law on it. Not everybody are technical experts or experts in their field. And more so, we can say that legislators are not experts in their field. Rather, they are appointed for the purpose of making laws in our country. So, generally the assumption goes like, so that does that mean that the legislature has no knowledge of the law? We always have to presume otherwise. We always have to presume that the legislature always knows the law and they know exactly what they are implementing as law, and that the legislature does not make any alteration in the existing law unless by express enactment. So let's say, for example, that the Companies Act of 2013 has been passed. Now, until I have received a written change in the law, I cannot presume that this law has been amended. That any alterations to this law will only be written or published through the express word. That means it must be published. It cannot be presumed or it cannot be spoken about in secret circles. Then, the legislature does not make a mistake. The court will not even alter an obvious one unless it is to correct faulty language where the intention is clear. I think this is the most important part. Where the intention is clear, even if it looks like there is a mistake over here, the court will not alter it because it is presumed that the legislature does not make mistakes. And when we had studied the provisions of constitutional law, we had clearly understood that the process of passing a law is so rigorous and is so time consuming and extensive that to find fault in every act of the legislature would tantamount to actually abusing the process of the legislature. So there is a presumption under law that the legislature never makes mistakes and that everything that they have put in the law is put in there for a reason. The court will mostly only try to correct faulty language, and if a person comes forth saying that the provisions of this law is violative or is unnatural or is causing more confusion, then they will have to prove it first before the court takes that interpretation. Then, the words in a statute are used precisely and not loosely. That means, again, we're going by the same interpretation that the legislature knows exactly what it's doing. The legislature knows that the presence of these words in the statute in the following manner is correct and that it was not put there by mistake. And that every single word of the statute must be given effect to. That mens rea or the guilty mind is required for a criminal act. There is always a strong presumption that a statute creating a criminal offence does not intend to attach liability without guilty intent. What do you mean by this? Now we're coming into the concept of criminal law. In criminal law, it is not enough that you simply do the activity. The criminal needs to show that the criminal does not need to show. The court needs to prove, or the state needs to prove, that he had every intention of committing that criminal wrong. This is what we call as mens rea, or also known as the guilty mind. Because to give you an example, first example could be that a person is driving on the road just trying to reach from one state to another state. While traveling on the highways, he happens to get into an accident and he ends up killing the person on the road. So here, while it may be called murder, we can say that the driver did not have any intention of killing any person on the road. In the sense that he did not wake up in the morning with the intention that, okay, today I shall kill a person. No, but he will still be punished to a slightly lesser extent compared to the second example. So what is the second example? Let's say a man goes to a shop, buys a very sharp knife, walks straight to his girlfriend's house and then stabs her 6 times. This is a clear case of intention. Simply by his action, he showed that he had every intention of killing that lady. Now, while both amount to murder, one is without any intention but rather through negligence, whereas the second example is a clear case of murder with a guilty intention. Okay. Now, it is always presumed that in criminal offences, that unless you prove an element of mens rea, the guilty person or the person or the accused person can never be convicted of that crime, because all criminal acts require a guilty mind. So these are some of the presumptions that we're looking at with respect to presumptions itself. As to certain other presumptions, it can be explained through understanding the concepts of international law, the concept of a legal fiction, and the doctrine of natural justice. So let's look at the concept of point number E, that is, a statute is not intended to be inconsistent with the principles of international law. Although judges cannot declare a statute void as being repugnant to international law, if two possible alternatives present themselves, the judges will choose that which is not at variance with it. So what is international law? It is our ability to stay in good relations with our international community, that our country will also be in the global stage by enacting a few laws. So whenever there is an inconsistency between two laws, that is between a domestic law and an international law, then most of the times the court will try to reconciliate between the two, because remember, our country also needs to get along with its neighbors. And if our laws state otherwise, then it may affect the friendly relations of the state. So wherever possible, the court will try to give effect to it. The next one. The doctrine of natural justice is a doctrine for the interpretation of statutes under which the court will presume that the legislature, while granting a drastic power, that it must be fairly exercised. So what does this mean? Generally, when a power is given to any person, and I don't just mean to a person of a higher posting, any person who's been given power will at any point, there's a 50% chance that he will abuse his power, and there is a 50% chance that he will not abuse his power. There is always a presumption there's a chance of abusing the power. I mean, I will not use the word presumption because it will mean that we're talking under this topic. I am talking generally, that we do not know the intention of persons, that they may choose to exercise it properly or they may choose to abuse it. However, since it is necessary in our country to give power to certain persons to help administer the country properly, we cannot say that, no, I cannot give you any power because there is a 50% chance that you are going to abuse it. So therefore, what do? We will give them the power by virtue of a law. And then the court will also presume that when a law is granting power to a certain individual or a certain office, that the doctrine of natural justice or principles of natural justice must apply over here, so that that power is exercised properly, effectively, and without any abuse. So what exactly is the principles of natural justice? We see that in chapter number 4, that is your administrative law. It is a principle which is in existence so as to keep administrative power in check. It is to ensure that proper process is being followed without its abuse, and that is only the principles of natural justice. So even though the law does not provide or does not specifically say that we are granting a power to said person for the purpose of doing so and so activities, and that person will be governed by the principles of natural justice, that may not exactly be written. It may simply be written that this person shall be appointed for the purpose of doing so and so work. Now what the court will presume is that whenever such a power is given to such person, that the principles of natural justice will apply to all of his actions so as to ensure that he is not abusing his power. Okay. Then the concept of a legal fiction. A legal fiction is, in essence, it's saying it would be proper and even necessary to assume all facts on which alone the legal fiction can operate. So what exactly is it? It is a series of statements which are known to be untrue, but which are allowed to be denied in order that some difficulty may be overcome so that substantial justice is secured. So what exactly are we saying over here? What is a legal fiction? Fiction, something that does not exist. Legal fiction, we are granting legal power to something that does not exist. That is what legal fiction is. A best example of a legal fiction is a company under the Companies Act, because what does the law say? A company shall be a separate legal entity. It should be treated like a separate legal person or an individual. So there can be me, who you can see. I am a person with a body, hands, legs, a face, etc. And then subsequently right next to me, they're saying that there exists a company which goes by the name Akash Private Limited. And this Akash Private Limited is a person as per law. This person is capable of holding property, selling property, can be sued, can sue, can conduct business activities and is a going concern. Okay, so we are giving a legal cloak to a fiction known as a company, and that is what we call as a legal fiction. So legal fictions are actually not in existence or may not be true even, but then for the purpose of law or for the purpose of justice, a legality has been given to that untrue thing so as to give effect to it. Okay, so this is what legal fictions are. And with this we'll come to the end of presumptions. Presumptions is the act of assuming something which may exist, which may not exist, but you're assuming something without even having to check whether it is actually in existence or not, or whether that proper procedure has been followed or not. It's just a presumption. Another presumption, an example that I can give you is, if you become a member of ICSI, that is, you get your membership number, it is automatically presumed that you followed all the proper necessary steps to get that membership number. That means you would have enrolled for your examinations, you would have cleared your examinations, cleared certain other technical requirements such as your training, seminars, classroom requirements, etc. That you have completed all of them. And that if you simply show your membership number, it is enough to say that I have completed all the due process under law. And this is a presumption.